So I wanted to thank everyone for joining us today. My name is Jay, and I'm an office manager here at Standpoint. So I want to begin today by reminding folks that this webinar is being recorded. When the link is available, I'll be sending it out to our legal advocates listserv and also add it on our YouTube channel and website. My role today is going to help facilitate the webinar. If you have any questions during the presentation, please type your question either into the Zoom chat box or the Q&A tab, and I'll make sure Heather can address your questions or comments. Most of you probably are a little bit familiar with Standpoint, but if you're not, or if you're listening to this later, Standpoint serves the entire state of Minnesota. We are a team of attorneys and advocates working to assist individuals who have experienced domestic violence, sexual violence, and trafficking when it includes domestic or sexual violence. We do this through answering calls to our action line. Our action line is answered Monday through Friday from 9 a.m. to 4. And it's through our action line that attorneys provide legal advice and our advocates connect callers with resources, safety plan, listen, and help identify possible options and next steps. Standpoint also provides assistance to systems professionals who work with survivors. Our staff facilitates training such as our annual new laws throughout Minnesota or monthly webinars such as this one and other trainings by request. Right now, I'm going to be sharing the Dropbox link in the chat. That has the PowerPoint if you would like to follow along, and then also some other handouts as provided by Heather today. So now I'm going to go ahead and introduce Heather. Heather Kolling is a victim services specialist for the Minnesota Department of Corrections. In her current role, she provides support to victim survivors who are in the community and those who are incarcerated. She has a master's degree in victim services management and a bachelor's degree in victim studies from Sam Houston State University. Prior to coming to the DOC, Heather primarily worked in community-based advocacy, supporting victims of domestic and sexual violence as an outreach manager for Hope Coalition and outreach advocate for 360 communities. So with that, now I'm going to toss it off to Heather.
Perfect. Well, with that introduction, I'm able to just jump right in. So as Jay said, my name is Heather. I'm a victim services specialist with the DOC, and we're going to chat today about taking a crisis call from an incarcerated person, specifically for PREA advocacy. So PREA advocacy covers sexual violence. So we're going to go a little bit through. There we go. A general overview today of the DOC, our Victim Services and Restorative Justice Unit, and PREA contractors, so community-based organizations that are already doing PREA work across the state of Minnesota. I'm going to provide some general recommendations for taking a crisis call, things you might want to keep in mind that might be different if you're working with an incarcerated survivor versus somebody who's in the community. And then we're going to discuss some unique barriers that incarcerated victim survivors face. As Jay said, I was primarily a community-based advocate so far for the bulk of my career. So coming into systems-based advocacy, I didn't realize some of the things I didn't even think about that our incarcerated victim survivors face. And so it was really eye-opening for me when I got here. So I'm really excited to kind of share some of that with all of you today. But please, as I'm going through slides, if you have questions, put them into the chat, put them into the Q&A. I've given Jay the instruction to cut me off if you all have questions, because I really want to make sure that the information I'm giving you is the information you're needing from today. And I want you to get something out of this presentation. So the first thing I want to highlight, I'd love to say we planned it this way because obviously we're having this webinar originally in July of 2023. Effective July 1st, the Minnesota legislator actually required that Minnesota Department of Correction provide free phone calls for all incarcerated people in Minnesota state prisons. The statute actually also specifically bars Department of Corrections from profiting off of phone calls in the future as well. So this is going to be a thing for the foreseeable future. This does also include international calls as well. There is kind of a committee keeping an eye on the cost of that at this point. But the plan is that all incarcerated folks will get free phone calls moving forward. And that began July 1. From a victim services perspective, I have some concerns for our folks in the community, but from a PREA perspective and supporting the victim survivors that are within our facilities, this is really exciting. It eliminates the barrier of cost if they want to reach out to the preferred community-based organization. It eliminates barrier of cost in trying to access the advocate they've been working with. So those things are really exciting. This is their calls directly to an advocate or a crisis line. This is separate from the confidential calls that our unit sets up for advocates with individuals in facility. They were never charged for those. But if the incarcerated person themselves is attempting to reach out, they are no longer experiencing any fees related to that, or to call their loved ones. This is everybody, but it also obviously will include our community-based organizations.
Heather, there's a question if there's a time limit on those phone calls.
Yes, 15 minutes at this point, just because everybody's getting free phone calls. And so everybody's really excited to call their friends and their family members. So right now they're limited to 15 minutes. And we've heard that there have been very long lines in the facility. We're hoping that'll kind of taper off as this just becomes the new norm. But right now, to ensure that everybody is able to make phone calls kind of every day and check in with their loved ones, 15 minutes is the limit. So I want to kind of distinguish, when I say we're from Department of Corrections, what does that mean? And so we have 10 state prison facilities within the state of Minnesota. So that is who Department of Corrections oversees, is those 10 facilities. And within our population, everybody within those facilities is there serving on a felony crime, and that sentence for that crime would have to be 1 year plus a day or more. If they get 1 year or less, or it's a misdemeanor or gross misdemeanor, they would go into a county jail. There's 93 of those in the state of Minnesota across the 87 counties. Those are not like overseen by the Department of Corrections. Those are run by the individual counties, those county sheriff's offices. So what I'm talking about today is specific to our prison population. I would highly encourage all of you to get on your county jail's website, see who the PREA officer is for that specific county jail. It is supposed to be publicly posted, and become acquainted kind of with that name, with that contact information, maybe introduce yourself. That is separate from DOC. So while within the PREA statute, the standards are written for both prisons and jails, obviously our procedures and policies and protocols may differ from what the county jail is doing, even though they have that same standard that they're going to have to follow. We do also have 3 federal prisons within the state of Minnesota. Again, those are not overseen by the Department of Corrections, but they are within our state. And then Minnesota does not currently have any private jails or prisons. Here are the locations of the 10 facilities within the state of Minnesota. I pulled our population numbers on Tuesday of this week, so July 18th, 2023. If you ever are curious how many people are in your local facility, you can go onto the Department of Corrections website. There's a facilities tab that has each of the different facilities listed, and there's a daily inmate profile report that you can click on that's populated every day. That'll tell you how many people are there right now. There's a breakdown of demographics. There's a breakdown of types of crimes those people are serving on, things like that, if you're just ever curious. But these are where those numbers were on Tuesday. So right now we have about 8,300 people incarcerated in the state of Minnesota within a facility, about 100,000 on community supervision. Prior to the COVID pandemic, our numbers were running right about 10,000. During the pandemic, we dropped down to about 7,000, 7,500, and those numbers have steadily kind of been going up in the last year. So now we've been kind of hanging out around that 8,300 number. We'll see if those numbers continue to go up, but right now that's where we're at. So these are where all the facilities are located. They're broken down by security type. So level 2 to level 5, we don't have any level 1s. I don't know why, but we don't. So level 2 is our minimum security. 3 and 4 would be medium security, 4 is close security, and then 5 is our maximum security facility, which is at Oak Park Heights. Here's kind of another way to look at it. So we have separated out the women and the juveniles. So Shakopee is our only female facility within the state of Minnesota. So all supervision levels or custody levels will be within our Shakopee facility. Right now for PREA reports, about 60% of our referrals come out of Shakopee, which shouldn't be a surprise for us, right? Knowing sexual violence numbers with females. All of our juveniles are housed at the Red Wing facility. All of our male juveniles are out at Red Wing. And there's also a small population of minimum security adult males that go out there as well. We also have the Challenge Incarceration program. That's like our boot camp program. It's the only one that can reduce some of their time within facility. Those are located at Willow River and Togo, way up north. And then our other minimum securities, we do have some minimum folks at Stillwater that work out of our canteen program, Faribault, Lino Lakes, and then those adult males that are at Red Wing. Our medium security is Moose Lake, Faribault, which also has our geriatric unit, and then Lino Lakes, which does the bulk of our sex offender programming along with Moose Lake. And then our maximum security is Oak Park Heights. That does also have our medical unit. So sometimes folks will be surprised somebody goes to Oak Park Heights. It may be because they're needing the medical services out there. Stillwater, Rush City, and then St. Cloud. For those of you in victim services, St. Cloud is our adult male intake facility. So every adult male that comes through the Department of Corrections will go to St. Cloud first, and then will likely be reclassified and sent somewhere else. So if you're ever working with someone and they wonder why they transfer out of St. Cloud, it's because most of the time they don't stay there long term. So all the females go through Shakopee, all the males start through St. Cloud and then can disperse from there. But I think it's helpful just to see our facilities. I want to familiarize folks with the DOC because sometimes, you might be familiar with your local prison, but might not know where all the rest of them are. So I just think it's helpful anytime I do these presentations, just to give a general overview of DOC and what we actually mean with the facilities we're talking about. So with that, I also want to introduce you to our unit. So this is just a quick overview of our unit. It's the Victim Services and Restorative Justice Unit. We are very small. So Liz Richards is our director, and then we have a restorative justice side of our unit. Sarah King is the coordinator. They oversee things like the restorative justice councils within each of the facilities. There's restorative justice programming that is done within the facilities. The apology letter bank, Chris Godsey approves those letters and maintains the letter bank along with Camille Buckley, who's the student worker. They're also working on a restorative justice directory for the state of Minnesota right now. And then we have our victim services side, which is run by Brittany Anderson's the coordinator for that. Myself and Andrea Stefani are the victim services specialists, and we have a student worker named Sam who does all kinds of things, including intakes for victims. And then we also have our end of confinement review committee contractors and our PREA contractors. We're primarily talking about PREA today. So these are the folks within our unit that do most of our PREA work. Liz Richards is our director. Some of you might recognize her name from the years she spent at Violence Free Minnesota. She came to our unit within 2021 to kind of bring it back from the ashes and put our unit back together. With PREA, she handles all of the MOUs and contracts with community-based organizations. So if your executive directors are wanting to enter into a partnership with DOC, wanting to get an MOU signed, so you all can do work within facility, Liz would be the primary contact for that. Brittany Anderson is the victim services coordinator. Fun fact for Brittany, she was the only victim services person at the Department of Corrections from 2019 to 2021. So if you ever see her, thank her. That was a big load she was carrying for those 2 years. I also make that point to say, if you've been doing victim services work and weren't aware that the Department of Corrections had victim services, that might be why the unit was disbanded for a couple years. Beginning in 2019 and was brought back together and has been growing since then. But Brittany was doing all of that work by herself in the meantime. But our unit is back in making a lot of progress and doing a lot of work within our facilities. So also just know we're here to help if you ever have questions about our facilities or supporting a victim survivor related to an incarceration. Brittany's work primarily with PREA is she is our PREA response. So she carries the PREA line with her. She also does the initial triage, that would be a fun little combined word we can use, but triage for PREA. When an initial report comes in, Brittany will get the information on the report, information on what the incarcerated person is wanting as it relates to advocacy, and then kind of review our available community-based partners to see who might be most appropriate. We've added a lot of culturally specific programs that are doing PREA work within facility and things like that. Brittany also actively tracks to make sure we're not doing any conflict of interest, especially when it's incarcerated person, non-incarcerated person PREA reports. We want to make sure we're not connecting the same program with both sides of a report. So Brittany does a lot of that initial work, coordinating, getting the release of information with the facility from the incarcerated person, and then making the initial reach out to the programs to see what advocate might be available to support the incarcerated person. And then there's me. A big part of my role with PREA advocacy is doing what I'm doing today. It's providing the support to the community-based advocates that are doing the work to kind of be that liaison between the community-based organization and the facility, answer questions that the advocate might have, try to get creative if the advocate's wanting to bring in programming or get specific support for an individual within one of our facilities, or just general debriefing and emotional support as well. That's really my role within DOC related to PREA, is to be here for all of you to answer your questions and make sure our incarcerated individuals are getting connected with the community-based organizations when they need it. I will do direct services with incarcerated folks. Some of them ask to work with people from our unit, especially around sexual harassment cases. Sometimes we have difficulty finding programs that'll do that work. We don't like to do direct services as often just because the confidentiality standard with me is obviously not going to be the same as what they would get with a community-based organization. So we are most often going to try to refer out to a community-based advocacy program if that's what the incarcerated individual is wanting. And these are the current PREA contractors for this fiscal year that are doing work across the state. When I put this together, this was really exciting. We had about 12 organizations signed up last year, and we're just short of 20 this year that are doing work within our facilities and supporting our incarcerated folks. I saw some folks from these programs join the webinar today, so I'm really excited to see all of you here. But it's just super exciting for us as a unit. Liz, Brittany, and I all have background in community-based advocacy, so we're really excited to see the DOC kind of continue to grow those partnerships with the community-based organizations and bring them into our facility to support the clients that we serve. It's been really fun to see that grow over the last year or two, and we're just excited for it to continue to grow. So thank you to all the orgs that are on here already, and thank you for the ones that are attending the webinar today to get more information. It's just super important that we continue to grow these partnerships so we can help the people that are really needing it. But if you're ever wondering how to do PREA advocacy, not to volunteer all of them, but these are some of the organizations that have advocates that have done the work and have worked with clients in facility. Many of them have been to our facilities. So just so you know who is doing the work within Minnesota so far, these are some of the names doing that work currently. So let's get to why you're here today. I'm gonna start with just reviewing PREA, so the Prison Rape Elimination Act. I just think it's important to look at the statute. As not fun as it is to look at the legal words sometimes, I think it's just important to know what we're starting with, what is required of the Department of Corrections under PREA, and what folks within our facility are entitled to. So here's the quick little history. So President George W. Bush signed PREA into effect in 2003. The point when it was initially signed in was really to evaluate prison rape, but it really was sexual violence across all carceral settings. To gather information, to do research into that, and then provide information, resources, and recommendations, and then subsequently funding to protect individuals from prison rape. So kind of the heart of that statute was, just because somebody's sentenced to prison does not mean they are sentenced to experience sexual violence. That should not be something that is in the typical course of somebody's incarceration. And we at the time and still needed to do a better job at making sure we were protecting our incarcerated population from that. Part of what that initial act did was to create the National Prison Rape Elimination Commission. So we like long names for things. They published their initial standards for eliminating prison rape in June of 2009, and then passed those standards off to the DOJ for kind of final review. The DOJ then came back in June of 2012 with their kind of final standards, which then became effective August of 2012. So when we're really looking at PREA, at the end of the day, it's a little over a decade old. So this is fairly new for victim advocacy and the world of all the things that we do. PREA just hasn't been around as long as some of the other things. So when facilities and programs are a little further behind, this might be why. For a long time, it took a while for the standards to trickle down, and then it took a while for the facilities to figure out how to enact some of these standards. And then the audits have changed over time, and so people are learning they weren't doing things correctly. So if PREA hasn't been in the normal course of, your training or education as advocate, this could be why. It's fairly new in our world, but it's good that you all came here today to get more information. The goals that have been identified in PREA are kind of threefold. So the first one is to obviously eliminate sexual violence in correctional and law enforcement facilities. The second one being to increase the accountability of correctional and law enforcement facilities, because obviously PREA covers incarcerated person on incarcerated person crime, but it also covers staff on incarcerated person crime. So one of the goals of PREA was to increase that kind of transparency and accountability across the board. All of our PREA audits are publicly listed on our DOC website. They're done every 3 years within facility. We tend to have about 3 facilities going through an audit in any given year. But all of that information for all of the standards is posted on our page if you're ever curious to see it. And then the third one was to provide the same level of care to victim survivors in confinement as victim survivors in the community. I will also say that's a big goal of our unit. I don't think we're entirely there yet. Change is slow within, the government and systems, but I do think we're moving in the right direction, and we'll continue to go that direction with these continued partnerships with community-based advocacy, with the increased support of our incarcerated population. We'll continue to move that direction. So again, that's why opportunities like this, participating in trainings like this, are just so important. The other thing is PREA standards apply across 3 categories. So sexual assault in facility, and that can be with incarcerated person as the perpetrator, with a staff member as a perpetrator, a volunteer, chaplain, medical staff, transportation staff, anybody within facility that covers. Sexual harassment while in facility, but it also covers prior sexual violence victimization. And that prior is defined for DOC as anything that happened before they came into our facility. So if they experienced a sexual assault at the jail, we would put that under prior victimization for us. Should go under sexual assault for the jail, but it would be prior victimization for us. We have some individuals that come in and report childhood sexual abuse. That would obviously be prior victimization. We have some folks that come in and say they were sexually assaulted right before they got arrested by somebody in the community. Again, all of that is covered under PREA, and they're entitled to the same PREA standards as somebody that experiences sexual violence within facility. We've seen a significant increase in the folks within facility making PREA reports or requesting PREA advocacy, and the vast majority of it is within that prior sexual violence classification, which is good because they're reaching out because they want the help and starting to process it, but it also means that our staff are getting more educated on what PREA actually covers. So it's important to keep in mind, it doesn't just have to be sexual violence that occurs within our facility. It can be things that happen within the community or prior to them coming into our facility as well. So I've been talking about the standards forever. I'm only going to talk about one standard in detail, and it's the one that applies to advocacy. I have a website down at the bottom. It's prearesourcecenter.org. That's a pretty good one-stop shop if you want to read the statute more in depth. If you want to kind of breaks down the standards in a way that I think is easier to read than actually looking at the whole statute. But this is the standard that specifically deals with advocacy and access to community-based organizations. So it's 115.53, inmate, detainee, and resident access to outside confidential support services. So the purpose of this standard is to provide incarcerated people access to emotional support services from outside the facility. And it goes through all the reasons why that might be important, right? The incarcerated people might not want to talk to people in facility. They might be reluctant to trust the system. Some facilities might not have the resources that they're looking for, might not be properly trained in sexual violence. So it's just really important that they get that confidential space and that safe space to process kind of what they're going through and what they're experiencing. And the community-based advocacy organizations are the place where they can get that. The second purpose kind of delineates, there is another standard that mandates that incarcerated people have access to an outside entity to report a PREA incident. So it can't just be they have to talk to facility, they have to have access to an outside entity to do that. The second purpose does delineate that the community-based organizations that provide emotional support are different than that reporting agency because of the confidentiality standards, right? We can't have the community-based orgs can't be the ones expected to investigate and report incidents that occur because of their confidentiality standards. So this just delineates that they're different, but they're both important. And that part of the requirements of the confidential support services is talking them through the reporting options if they want to do that, similar to what we would do for a survivor in the community, right? Talking through the different options that they have, talking through their different ways that they can report, pros and cons to reporting, access to SANE exams, things like that. So it is also expected that the support services would review that, but not necessarily be the external reporting agency. So requirements of the standard. There are 3 requirements outlined within this standard. The first one being the facility has to give incarcerated people access to victims advocates outside of the facility for emotional support related to sexual abuse. They have to be able to do that through the phone, through mail. And the part I really wanted to highlight here is this is the part of the statute that requires that the Department of Corrections or the incarceral setting provide these services in as confidential a manner as possible. So as you can imagine, in prison, there aren't a lot of things that aren't on camera or aren't recorded. So this requires incarceral settings, law enforcement facilities, correctional facilities to allow incarcerated folks to speak with their advocate in as confidential a manner as possible. So at the DOC, we'll set up confidential calls. Those typically happen in like the same spaces like a legal call would happen, or the same spaces like a court hearing would happen, where they might be monitored, but there's no audio recording. Like monitored, like somebody can see that they're in there, but they wouldn't have somebody else in the room with them. They wouldn't have any audio recording, things like that. So they can talk to their advocates in a space where they're alone, that's not being recorded. So they don't have that fear of somebody kind of overhearing their conversation. This, however, does not absolve community-based advocates from their confidentiality standards. This is just the requirement that gets placed on the correctional facilities to provide that confidential space, if that makes sense. The other 2 parts of the standards, the first one is facility has to inform incarcerated individuals of that access that they're able to have and the extent to which reports of abuse will get forwarded to authorities and kind of how that process works within facility. Anytime somebody comes into DOC, they kind of have like an orientation that they go through at either St. Cloud or Shakopee, which outlines PREA, outlines their reporting options, and everybody at intake has a PREA questionnaire that they get asked, which is often where we get a lot of our disclosures. So that's how we typically satisfy that piece of the standard. And then the final one is the agency, so us, shall maintain or attempt to enter into an MOU or other agreements with community service providers that are able to provide inmates with confidential emotional support services related to sexual abuse. So that cloud I just showed you of everybody doing the work right now, all of those organizations have an MOU or a contract with the Department of Corrections to do this work. For advocates to be able to come in to do a confidential call with an incarcerated person, our unit maintains a list of advocates that have gone through a background check, the MOU or contracts that we have with the various organizations. All of the advocates that come in have to have completed the 40-hour state mandated training for supporting victims of sexual violence. And then we also have a DOC orientation. It's like an hour long that they have to go through as well. So that's how we maintain this piece of the standard. So we can have advocates coming in if they want to do in-person like confidential calls and things like that with the incarcerated folks. So this is the federal standard that requires that Department of Corrections, jails, everybody allow incarcerated folks to access victim services, victim advocates from community-based organizations if they request it related to sexual violence.
We do have a question, Heather.
Yes.
If an inmate has already reported concerns to the prison designated person and then reach out to a local advocacy agency requesting assistance with reporting, since the internal investigation did not lead anywhere, what is the advocate role there?
So there's a couple options. If they don't feel like the facility did a proper investigation or there was some like misuse of their position within the facility, they could connect with the PREA compliance officer. So we have one statewide that oversees all the facilities. There is also an ombudsman's office that's run through the state that is separate than the Department of Corrections that does investigations into DOC allegations that can be made by anybody. They can be made by incarcerated individuals. They can be made by family or friends. They can be made anonymously. So I guess my suggestion in that situation would again be to just inform them of other options. So they could file a grievance, they could connect with the PREA compliance officer, or they could connect with the ombudsman's office would be kind of the next places to go if they don't think the facility acted appropriately. I hope that answered the question. I will also say, if you ever get a question from an incarcerated person that you're unsure how to answer, you're always welcome to call our unit. You can call me specifically. My direct contact will be at the end of this. I don't need the incarcerated person's name. You can just ask me a general question like, hey, like you just did, if an incarcerated person has this kind of question, what would be the options, or, what would be helpful? I'm always happy to answer those questions and provide that information for advocacy. If that did not answer your question, please ask it again another way. Thank you. All right, so let's go into crisis calls, right? Now that folks can have free phone calls and they can be making them directly, I again want to clarify, this would typically then be an incarcerated person choosing to make a crisis call from the phone that they have access to. So this is different than the confidential call. It would be the incarcerated person reaching out on their own. It would likely be on a shared space. It's going to be for that 15-minute interval. And it could be recorded and monitored. There isn't somebody like actively listening to calls at all points. But again, these are just things to keep in mind. If you did get a call directly from an incarcerated person, they would know that the call is likely being monitored, and so still obviously chose to make the call anyway, but just keeping in mind what type of detail we're asking them to give on that initial call, because they are likely in that shared space like I talked about, and that call could be monitored. So trying to kind of get that bare minimum information and then maybe following up later and setting up a confidential call might be the best way to go. But if they make that initial call, we obviously want to provide support to them. We don't want to just cut them off. They're reaching out for help. So how do we do that? What are some best practices? How could this be different than a call you can take from a community member? This is what I really want to get through today for all of you. So the first thing I want to say is you all can do this. I don't want folks to panic if they get a call from an incarcerated person. Incarcerated survivors are just victim survivors who need advocacy and support. One of the PREA advocates went out to do their first in-person meeting with an incarcerated person, and they told me after the meeting that they were really afraid when they first went in because like fear of the unknown. But then once they had the conversation, they realized it was just somebody needing to talk about their experience, and they very quickly went into that advocate role and realized they didn't know what they were doing. I just want everybody to remember to breathe, and you can do this. We take crisis calls every single day. This has some differences, but not really. The overall themes are still going to be the same. So you all can do this. I have faith in you, but we're still going to give you some tips on how to do it. So the first thing you want to do is still take demographics, right? We all take demographics for our databases, for grants, for all the things. You would still just obtain demographics as you normally would with any crisis call. There might be some additional information, however, that you would want to collect and kind of, note on your end that would just make like coordinating PREA response or coordinating working with our unit to set up a confidential call or sending them mail later easier. So you want to ask them for their OID, which is their offender identification number. That's how everybody gets kind of identified throughout DOC, and what their current facility is. You also might want to confirm current facility on subsequent calls. For female callers, this isn't going to be a thing. They're always going to be at Shakopee. But for any male callers, you might want to confirm that they're still within the same facility, because it is fairly common that they might transport between facilities as they get different jobs or join different programming, things like that. So just always make sure you're double checking. You could ask about their county of commit or their county of historical ties, especially if they're coming up on release soon. This would just help with like resource referral, resource recommendations, things like that. It might also help with like reporting options, talking through different reporting options depending on where the sexual violence occurred. If you do forget to ask this information, you could publicly find it pretty quickly, or if you don't want to ask this information, because it takes up part of your 15 minutes with the incarcerated person, you can pull it from the Minnesota Department of Corrections offender locator. Anybody that's within a DOC facility or under community supervision, a current picture, their name, who their caseworker is, what facility they're in, if they're not in facility, who their supervising agent is, what their committing offense is, and what county it's out of. All of that is going to be publicly available on the site if you just search their name. So I do want to let folks know, if you forget to get it, you can access that information somewhere. I will tell you, most of our folks know that they need to put their OID on a lot of things. So a lot of them might just give it to you when they first call. So if they say their name and give you a 6-digit number, that is that offender identification number. If you get letters from them or phone calls, most of the time they're just in general going to provide that OID as well. But it's important to get that information because it'll just streamline any releases we might have to get or conversations you'll have with facility later. I also just want to address conflict of interest really quick. We recognize, right, the work that we do in community. A lot of times, folks that commit domestic violence, sexual violence are housed with people who commit similar crimes within facility and therefore then may experience sexual violence or sexual harassment from folks kind of within their living units. So there may be a time, or it may become an issue, that it's a conflict of interest for your organization to work with that person. And that's totally fine. In all situations, I would just encourage you to default to your agency's current procedure for conflict of interest. If it is for a PREA case, you could direct them back to our unit if you wanted, or you could call our unit to see who else is doing PREA work that might make sense to refer somebody to. We're happy to provide that information. We just want to, again, we statutorily have to provide folks with PREA advocacy if they're wanting a community-based advocate. So if your agency has a conflict of interest and somebody is still wanting assistance, we're happy to assist with that. Again, you don't have to tell us the incarcerated person's name. If you're wanting just to give them an alternative program that they could call, we'd be happy to just give you another program that you could recommend somebody to. For other forms of victimization, sometimes people call and they allege that they experience like brutality from law enforcement, or they experience child abuse or domestic violence. It's totally fine to just follow your agency's current procedure for conflict of interest. If you are going to send them to another program or recommend that they call another program, just keep in mind that the facilities can't call toll-free numbers. So don't give them the 1-800 number to call, give them whatever the local number is, because that's the number they'll be able to call out on, not the 1-800 number. Okay. Gather information. So we want to start with what prompted them to call today. What are they asking for assistance with? If it's sexual assault, sexual harassment, or prior sexual violence victimization, it's covered under PREA, and therefore victim services is entitled to those confidential spaces, confidential meetings, things like that. If it's another form of victimization or release planning, like they're calling because they want to join a support group when they get out, or they are seeing if they can come to shelter when they get released, or they're wanting, I don't know, financial assistance, things like that related to release. Obviously default to your agency's, policies and procedures for providing support to those folks. It's just not entitled to the same confidentiality practices within our facility. So you can still have those phone calls, you can still mail back and forth, things like that. It's just not something we can necessarily set up those confidential spaces for at this time. We would love for that to change in the future. But right now, this is where we're at. Next thing you want to do is that crisis intervention. Again, this is similar to community. What do they want assistance with? Are they wanting more information on reporting options? Like I talked about, we have the Ombudsman's Office. We have our Office of Special Investigations, or OSI, within facility who do investigations. Are they wanting to report to local law enforcement? Is it something that they're wanting to report for potential criminal charges? That happens from time to time. Are they wanting to file a grievance and go up to the PREA compliance officer, right? Talk through those reporting options just like you would anybody in the community. Talk about pros and cons. Within the PREA standard, I mentioned it on the third bullet point, they are entitled to an advocate as a part of that interview. So if they do decide they want to report and they want to meet with OSI within facility, or they want to meet with local law enforcement, they can ask to have an advocate with them, just like anybody in the community can. It is the same kind of practices in community, though. It might be offered, but the incarcerated person does have to assert that right. They do have to say, I want an advocate with me. We'll then work to make that happen. They won't have the interview without the advocate if that's what they're wanting. But that incarcerated person does need to assert that right, but let them know it's an option. It's important for them to know they can have somebody with them. They're also entitled to a SANE exam. Just like in community, if the assault happened within the last 10 days, they're entitled to a SANE exam. The SANE exams happen off facility. That's not something we do within the facility. They would get taken to the local hospital, and then we defer to that local hospital's process for contacting an advocate, right? So they would call the same nurse, they would call the local advocate, and the incarcerated person would be entitled to the same procedure that somebody in the community would when they go to that hospital for the same exam. So again, depending on what they're calling about, wanting to talk through those options for the same exam. If court accompaniment is an option, again, if there's criminal charges ongoing, we've had folks within our facilities who are victims of other cases that are ongoing within counties or even at the federal level. Is that something your agency could do? Could you provide that court advocacy with them as well? And just in general, emotional support. A lot of times, as individuals are processing kind of their own accountability and things that they may have done and harm they may have caused that landed them within one of our facilities, that often comes with remembering the abuse that happened to them. And so figuring out how to deal with that and process it in an environment like prison, and going to prison itself is a trauma, right? It's a new trauma. And so that can be triggering for past trauma. Learning how to process that in a setting where you don't have control over your environment can be really difficult. So again, just having somebody they can call that's not within that facility, where they don't have to be concerned about running back into them or what reports are going to get made, is just really crucial. And so doing those general crisis intervention calls where we're just providing that emotional support is really what's most important. And then also resource referral at the end. Are there books that they could pull out of the library to read? Are there trauma workbooks where we could send them a chapter in the mail? Are there other agencies that might be more appropriate for them to call? Do they need to maybe access behavioral health and facility? Do they need to go to medical services? You know, what kind of resources also would make sense for them that they either have access to or that we could send in to them? Again, looks very similar to what you would do with a community-based victim services or victim survivor, excuse me. It's just what you're saying and how, like, the environment that the victim survivor is in is going to look different. And we have to take into consideration that the victim survivor we're talking to is incarcerated. So they're not going to have the same access to different resources or different coping skills that somebody on the outside might. Okay. The other thing we really want to do, again, which I hope we're all doing with community victim survivors as well, we want to clarify the limitations of advocacy. We don't want advocacy to be a substitute for, you know, behavioral health or medical services. They should be accessing those within facility. Like we talked about before, there is that ombudsman's office to investigate DOC policies and procedures. So if they feel like a policy at DOC or a procedure at DOC is unfair, they can file a grievance, but they can also go to that ombudsman office, who's like that outside entity, like I said, that'll look into those things. If they're trying to get you to do release planning services for them, like to find a house for them or, you know, get them connected with social services or sign them up for health insurance, there is release planning staff within the facility that would do that work with them, including like resume building, getting them a driver's license, things like that. So again, we don't want advocacy to have to do that when they have resources available to do that. And as always, just clarifying differences between advocates and attorneys. So we do have incarcerated folks that sometimes need to get OFPs or HROs, and obviously an advocate can assist with that, but clarifying if they're wanting to like appeal their criminal case, they need to connect with an attorney. That's not something an advocate would necessarily do for them. And then the final thing is, don't make promises that you can't keep. Our population doesn't always get to interact with, you know, as many new faces and new voices. And so they do a lot of things out of survival and ask for things out of survival. We just want to make sure we're not making any promises that we can't keep, like communicating with certain people, victims, family, things like that, sending them certain things in facility. We also don't want to make any promises like, oh, we'll make sure we get you out of that facility or we'll make sure we get you home. Those are just things that aren't within our control. And so just like with community victim survivors, we don't want to make promises that are outside of our control to keep. It's the same with our incarcerated folks.
We do have a couple questions, Heather. One of them was just an add-on to that first question was, what about an inmate requesting to be connected to legal resources because they want to see if they can get less prison time due to a PREA report? Do we get them resources or redirect them back to PREA staff? That was a lot.
Either is fine. It's depending what they're wanting. So there are legal resources available to them within the library. They can do, legal research, things like that. If they're wanting to talk to a lawyer, you could just give them phone numbers. There are plenty posted all over the facility. But I mean, if you wanted to connect them with like an Innocence Project or something like that, Gender Justice Project, I know has done work with some of our folks as well. Like I said, they have the free phone numbers now, so you could give them the phone number to make that initial reach out. If you are comfortable making that initial reach out and making that referral to that agency, that's something I would default to your program for, if that's something you would do in your standard practice. But those legal organizations could then set up legal phone calls with the incarcerated person to talk through those options. So that's not something that would have to be PREA specific for the lawyers to have access to. And those programs work with our facilities all the time and know how to set up those legal calls.
Thanks. Okay, there another question was related to the release planning.
Mhm.
Are those release planning services available at the local jails too, or just DOC facilities?
I'm only speaking to DOC specific. So I would get to know your local jail. I would reach out to that PREA officer, like I said, maybe ask them what their release planning process looks like. I would imagine it might look different just because they would have a quicker turnaround for a lot of their folks. All of our folks are coming in most of the time for a year or more, like I said. And so planning for their release might look a little different than somebody that's been in jail for 30 days, right? It might look a little different. So what I'm speaking to is specific to prison. I would redirect you back to your local jails to get that information. Anything else, Jay? Are we good so far?
That looks like it's it so far.
Okay, I will keep going. Please keep putting your questions in. I appreciate them. Okay, this slide, when I first made it prior to the free phone calls, was way more complicated. It's a little easier now. Determine the best way to follow up with the incarcerated person. It is a little easier now, right? Because they can call back for free, and so they're not getting charged if they have to call back. The advocate, however, does not have the ability to call the incarcerated person back. They don't have like direct lines. It's not something like a staff member would go notify them that you're trying, to call them. So you would need to kind of determine how you're going to communicate. That could be kind of a scheduled return phone call, like, hey, I want to pull this information for you. Could you call back tomorrow afternoon or something, and see if the incarcerated person's okay with that. You could provide the phone number for the PREA advocate within your program if there is one that's doing PREA work, or a community-based advocate that would be most appropriate for them to work with within your organization. And we're leaving that up to the programs. Again, now that they're having free phone calls, that might be a little easier. But I know some advocates have been on the fence kind of about giving that information directly to incarcerated folks, so that we're just leaving up to the comfort level of the programs. Other options for getting materials to an incarcerated person would be sending it via mail. So again, on our DOC website, it's pretty clear, kind of lays out how to send mail. It has all the addresses and things like that for the facilities. It could be special mail if you're, sending it from your program. I do want to encourage folks to keep a couple things in mind. They are only allowed so much property, so I wouldn't recommend like sending full books or anything like that, because they are only allowed so many. Our population does really well with like workbooks and things that they can do kind of on their own. I would recommend looking at the current materials that you recommend for folks to see if they're kind of prison friendly. Like, if we have books that tell people to like go take a hike on a mountain and walk through nature, like gather all these materials and do something, that's not something that's going to work for our incarcerated population. So maybe going back through like grounding skills or coping exercises or the trauma books you might recommend, and just kind of seeing if they are prison friendly, if it's something that would work within our facility. I would highly recommend doing that, but mail can be a good option, especially if you're just trying to answer a question or get them contact information for another program. Mail can be a good option. You could also refer them to books or resources available in the library. Our libraries are pretty well stocked. If you're wondering if we have something within one of our libraries, you can definitely ask our unit. We'll reach out to the librarian, let you know. If there are books you would like to see within our facilities, also please get that information to our unit. Our librarians have been very invested in wanting to kind of grow like our trauma collections. And so we've been slowly doing that, especially at our Shakopee facility. But if there is like a book or something like that your program typically recommends, definitely let us know so we can work on getting those things in facility. The other thing would be if they are willing to sign a release of information. If they're willing to sign a release of information, and our releases are specific to just scheduling the confidential calls. We don't need details from those calls. We don't ask for them. We also don't ask what happened. We rely on our programs that they're reliably meeting with folks related to PREA incidents and that they're providing advocacy appropriately. That's why we have them go through the DOC orientation and the background check and things like that. If they're willing to sign a release of information, you could either mail it to them and see if they'll get it in, but to avoid them having to pay for a stamp or anything, what would be easier is if you let our unit know, we'll send it to their case manager or directly to them, and then they can kite it, which is the internal mail. They can kite it back to our unit, and then we'll get it to you and we can start setting up confidential calls. But when you're determining that follow-up, that would be a good place to kind of ask if they are willing to sign that release of information, because then you could just work directly with the facility staff to set up ways for you to communicate with the incarcerated person and have those additional phone calls in those confidential spaces. Look at that. Discuss confidentiality limitations. Again, the standard that our facilities have to follow, and jails as well, is in as confidential a manner as possible. All the calls made from facility, if it's not previously set up as a confidential call, is subject to monitoring and recording. The confidential calls can be set up with our unit's assistance per the current DOC PREA policy. If you're having a confidential call with an incarcerated person, we do require that your agency have an MOU or contract with the DOC, that the advocate that's doing it complete a background check. They have to have their 40-hour certificate. And then there's that short DOC orientation that they have to go through, which we do over Zoom. It's not anything that has to be done in person. And we're also working on recording it right now, so you wouldn't even have to set up the time with our staff. You could just watch it once you had availability. That is what our current PREA policy says for the community-based agencies that have been providing the confidential services within facility. So if you start working with somebody and you're an agency that hasn't worked with us before, we'd be happy to get that process kind of set up for you. If you don't feel like you can meet their needs, via mail or via the calls that they're having with you from their shared space. It's again just important to remind them that they are on a recorded line, so it could potentially be recorded or monitored. And then for the advocates taking the call, just always keeping in mind that 15-minute window you have, and that they're in a shared space. They're in their living unit when they're making those phone calls. And so again, just not requiring them to divulge too many details, or if they're being vague on details, maybe understanding why.
There is a question: are PREA calls to community-based agencies mandated reports?
That's a wonderful question for Standpoint staff. No, not necessarily, right? Because PREA reports could be prior victimization, right? So it could be domestic violence that had a sexual violence component before they came to a facility, which wouldn't be a mandated report. I would argue if you find out that a staff member is sexually assaulting an incarcerated person, that would probably be a mandated report, but I would encourage you to default to your program's mandated reporting requirements, and Standpoint is available to ask questions. So it would depend on essentially the nature of the crisis call, in my opinion, if it was a mandated report. But I don't think all PREA calls are necessarily a mandated report. And that's not going back to this standard. It's specified that the community-based organizations that are providing emotional support are not the reporting entity. They're not expected to be the reporting entity outside of those mandated reporting requirements. Okay. I wanted to talk through some unique barriers that our incarcerated folks kind of face. These are just some things that I think advocates need to keep in mind when you start working with an incarcerated individual, and really just looking at how this might impact the services that you would typically provide with a victim survivor. So again, mentioned this before, somebody asked early on, but the phone calls are free, but they are limited to those 15 minutes to accommodate everyone. They're going to be made from that shared space. Confidential spaces are also limited. There's typically only 1 or 2 rooms within facility, and those rooms are being shared by people that are having court hearings, because those are all online now. People that have legal calls with their lawyers, or some folks have like ongoing like CHIPS cases and things like that. They might have meetings with their own kids and things like that in those rooms. So also keeping in mind when you're setting up those confidential calls, you're likely not going to be able to do it every single day, maybe not even every single week. I know a lot of our PREA advocates currently doing the work might call somebody for like the first 2 or 3 weeks, and then they go to monthly after that, with maybe sending mail in between with like journal prompts and things like that, or resources. But those are just things to keep in mind. The facility is also just kind of limited in the amount of confidential spaces that they do have as well. Case managers have significant caseloads. Again, I think we hear case manager, and I think in the community it means something a little different than in facility. Most of them have a caseload of like 100 to 150 people. So they might not know the ins and outs. Oftentimes the case managers don't even know somebody's made a PREA report. So if you're wanting to ask questions about the person or how facility works, most often our unit is going to be a better contact to do that than the caseworkers. Non-PREA qualified victimization isn't currently entitled to the same level of confidentiality by facility. Obviously, if you're working with somebody, our unit wants to be assistive to you in continuing to provide those services. We want folks who are incarcerated to learn and grow and heal as much as they can while they're in facility. And so if they are getting services, we want to assist with that. They're just not currently entitled to the same confidentiality by the facility as the sexual violence victimization is. Some barriers for the incarcerated person. They very often have a set schedule. So they don't, like folks that are in facility to not be doing things. So they're typically going to programming or treatment, or they have a job, they have meals at a specific time, they have to shower at a specific time. So the incarcerated person might not have a lot of flexibility in their schedule. Also, in the same breath, you might schedule a phone call with an incarcerated person, and then the facility goes on lockdown and they don't have immediate access to it at that time. There's counts at a very specific time, and they have to be within a specific place during those counts. So just keeping in mind that they have a set schedule that they might have to follow. So if you're setting up a phone time and it's not really working for them, it may be because of that set schedule. The incarcerated person may not be able to access typical forms of coping. Some of that may be a good thing, right? Like might not have access to substances or things like that, some folks in community use to cope. But also things like not everybody has art supplies readily available. Not everybody has immediate access to nature. Some facilities do, some facilities don't. So it's really important that you keep in mind some of those coping skills that you might recommend to somebody, or grounding exercises that you might recommend to somebody that's on a crisis call. Just keeping in mind if that's something that could be done within a prison setting. Also, if it's something that isn't going to bring a ton of attention to them as well. They're all in living units where a lot of people are around them all the time. And so if they're doing some coping skill that everybody is going to be able to see and know what they're doing and ask them about and kind of force them to disclose, might not be the best coping skill, to recommend in the moment. So that's also just something to keep in mind. I know, especially at our Shakopee facility, tapping has worked really well. There's a lot of those kind of the coping skills and grounding exercises they can kind of do within their bodies are usually the most helpful ones. They have restrictions on the amount of property that they can have. On our website, if you can't find it on there, I'm happy to send it to you. We have like a friends and family handbook that kind of outlines the amount of property, amount of books, things like that they're allowed to have. So if you are going to send paperwork and things like that, just keeping in mind what they already have access to. Triggers could also lead to behavior which may result in segregation. This is really difficult. It's something we see within our units. That we're really trying to work with facility on. When somebody becomes triggered and they scream or they get loud or they throw something, that could result in them getting placed in segregation, which might limit their access to the phone or might limit their access to programming or other things they would typically use. And so it can be hugely helpful from an advocacy standpoint if we can start to help them learn to process those emotions, learn those coping skills, so we aren't having those big outward displays that do result in segregation. And then again, just general fear of the system, calling you all needing to talk to us, potentially needing to report to us so they can get to a new living unit or report that they're being assaulted by another incarcerated person. That's really scary. I mean, they obviously are already involved in the criminal justice system. Like I said, coming to prison in and of itself is a trauma. And so the idea of having to disclose more and almost be more vulnerable can just be really difficult for an incarcerated person to do. And so we already work with victim survivors that have fear of the system, but this is another level of that, that we just always want to be cognizant of as we're providing support to these incarcerated folks.
There was a clarification question about the release of information that you were talking about earlier.
Yes.
To clarify, if an incarcerated person calls our hotline and wants to be set up with PREA services within facility, we would get an agency ROI signed and then reach out to the VSRJ unit to let y'all know, so that you can get a DOC ROI signed by them and set them up with PREA services. Or should we suggest they reach out to your unit directly to request services? Wanted to make sure I understood correctly.
What I think would be easier, because technically that they're within our facility is already public information. So really, we're typically getting the release of information really just for the community-based organizations. What I would recommend, if your agency is comfortable with it, would be seeing if the incarcerated person is okay with you just reaching out to our unit to get them to sign a release of information, because then our unit could more quickly get them the release for your organization to get to you. So then we could continue to work together to schedule a confidential call, if that makes sense. So we do have a DOC version we sign that says we can exchange information, but I know most programs prefer to have theirs signed. And so most frequently agencies will send me or directly to the incarcerated person themselves the release that they want them to sign. And then once the community-based agency has that release, then they have the freedom with their confidentiality to talk to us, to let us know, hey, this person called, they're needing PREA advocacy. Can we get a confidential call set up? If that makes sense. The ROIs are primarily for the community-based organizations and respecting their confidentiality that's required under their standards. If that didn't answer your question, please ask another one. This is the primary challenge that we have as advocates in supporting people who are incarcerated who have experienced sexual violence. How do we give power and control back to someone who has inherently lost power and control over their body? So they are not in control of their living space. They have some control. Like, I don't mean to say they've lost all body autonomy. They haven't, right? But they've lost control over their environment. They don't get to leave whenever they want. They don't get to call whoever they want whenever they want. They don't get to go wherever they want, right? Like, that's the difference. And so how do we give power and control back to this victim who doesn't have power and control in the space that they're in right now? That's the challenge we have in front of us. And that is what often triggers people who have prior sexual violence victimization to disclose when they're incarcerated. But that is the challenge we have. And that's why some of the coping skills, some of the strategies that we use with our community-based survivors might not work in our facilities. And so that's kind of the lens I just want to remind advocates to keep in mind when you are supporting somebody who's in facility. Is the strategy, the skill that you're recommending to them or discussing with them something that they can feasibly do within facility? And these are just some general questions kind of to consider. I've already talked about some of them, right, with the coping skills and the grounding exercises. What trauma books do you recommend? Are those books prison friendly? Do they recommend things that could be done within the prison? How can we modify the way that we are already doing our advocacy to make sure we're incorporating incarcerated survivors into the prevention work that we're doing, into the awareness things that we're doing, like including the incarcerated population and incarcerated survivors kind of in those considerations? Does your organization have policies in effect that would impact your ability to support somebody that's incarcerated? Would your agency work with somebody who's committed domestic violence or sexual assault? What about child abuse? What about homicide? What about stalking? Does your agency have anything that would prohibit your ability to work with somebody? And then what biases might we have in supporting an incarcerated person. We spend a lot of time and effort and energy, right, supporting victim survivors as they move through criminal justice systems and move through sentencings that might see their abusers go into a facility. So if we have to turn around and be on the other side of that and support an incarcerated person, what biases might we have kind of going into that, and how do we have awareness of that, and make sure we're just being that open, non-judgmental space for those people that we support. These are big questions that I threw at the end of the slide, but I didn't have all day to talk to you. I only had an hour, but these are the things that we have to think about as community-based advocates as we move forward and look at resources that we use and look at policies that we put into effect in our program, and look at prevention and things like that we're doing, making sure we're keeping in mind those incarcerated folks that we might also be supporting. That was everything I wanted to cover today. You guys have asked some great questions. I realize this is very confusing. I also realize it's confusing that we have confidentiality standards that facility has to follow, and then Minnesota has the standards that advocacy has to follow. So I know this all can get kind of muddled and confusing. And then we have prison versus jail versus juvenile. It's just a mess. I totally get it. So if there are questions, please feel free to add them into the chat and the Q&A. I'm going to go ahead and just put up my contact information now. So my contact information is obviously on the left. That's my email and my work cell. That is also contact information that can be given to victim survivors as well. So if you're ever working with anybody that needs to talk to me, feel free to give that out. We do also have a general victim assistance line that I also put up on the right. That's a victim assistance general email and general phone number. Excuse me. Again, feel free to call that. We do have an office administrator that answers that during business hours. And then obviously you can leave a voicemail after hours. And I believe these are also referenced on those handouts that Jay put in the link in the Dropbox. I designed those handouts, especially the one pager, as something that could go up like on a board or something like that by where you might be taking your crisis calls, as like a quick reference. Because I recognize you could do the webinar today and not get a call from somebody in an incarceral setting for months. But I wanted you to have something that you could quickly reference if that did occur. I tried to give you all some time to type. Did we have any questions that came in, Jay?
I don't see any that came in here in either the chat or the Q&A.
Okay, well, that was everything I had for folks.
Thank you so much, Heather, for joining us today. And as I mentioned in the intro, I'll be emailing out the link to the recording. Once we have that available, I'll email it out to our advocates listserv, and it'll go on our YouTube page as well. So thanks, Heather. Thanks everyone for joining us today. And I'm going to now end the webinar.